So good morning, everyone. I am absolutely excited to be sitting here next to Dr. Justin Koo, a guru in intellectual property. He's an absolute expert, and we have brought him here today to actually give us the insights, give us the in-depth knowledge that we need as entrepreneurs and business owners to scale up our business. So this morning, he's not only going to be sharing with us what he knows about intellectual property, but we've actually gathered some key questions from the entrepreneurs and business owners of Scale Up TT. And these are the questions that he's really going to be focused on to give us a good guide and a good sense of how we can move forward with intellectual property rights within Trinidad and Tobago. So good morning, Justin. Welcome.
Thank you for having me. And I'm really glad to be able to talk about intellectual property today. This is my passion. And any opportunity I get to share this information, I'm really glad to take it.
Thanks, Justin. Really, you have no idea how much we need to know and how much we don't know that we don't know.
Yeah.
So I'm really glad to have you here. So one of the first burning questions we have is, what are the main types of intellectual property and how does it differ from each other?
Yeah, so under the term intellectual property, it's an umbrella term. So you actually have the most popular rights that we're all aware of: copyright, trademarks, patents. But in addition to those three, which are as I said, the most popular ones, we also have design rights, plant variety protection, chip protection, geographical indications, increasingly trade secrets being seen as intellectual property. We also have, again, one here. There's an umbrella term for all the intellectual property rights. So how do they differ? Well, they cover different subject matters. So plant variety protection covers specific strains of plants. Geographical indications cover products coming from a particular geographic location with specific characteristics. And then in terms of the most popular ones, trademarks, copyright, patents. Patents covers inventions. So you invent something, you invented a pen, you invented a phone. Phones, for example, have thousands or sometimes hundreds of patents in them. You have copyright works, which cover literary, dramatic, musical, artistic works, films, sound recordings, that sort of thing. And trademarks, which is probably the one that is going to be most relevant for all the startups, because everyone is going to have a brand. You're selling your product under a brand.
Gotcha.
You got a logo, you got a name, you got a slogan. Those come under trademark. So I guess over the course of today, we're going to explore all of these options.
So that's a lot. That's a mouthful.
It is. It is.
So as you can appreciate, Trinidad is a multi-sector space where we have multi-sector industries. Where can persons say, okay, this is where I can go to figure out this is where this is the patent that is reflective of my particular industry, and these are the steps that I need to follow in order to register my patent? Where can that information be resourced, and what are the steps involved?
Yeah, so in terms of patenting specifically, the starting point is to have an invention. And the real key element of that invention is that it has to be novel. Means it has to have not have been done before, and that's not just in Trinidad, but in any country around the world. So when you're running a patent search, you need to check online. There are patent search databases online. So the USPTO, that's the US Patent and Trademark Office, they have an online database. WIPO has a database as well. Some of the other intellectual property offices are listed online. So that's your first point of contact, I think. Just do a regular Google search. Google itself has a patent database.
Oh, excellent.
So you can do a Google patent search, and you just type in keywords that refer to your invention and see if anyone has done something or something similar. You might need to try some variants of those words to just catch the range of cultural differences and the way that terminology is used. But that's your starting point to determine if you have something that's novel and is going to be potentially patentable. So as I said, patents cover inventions. So it's not the idea in and of itself, it's the idea that is capable of industrial application. So if your idea is not capable of industrial application, then you can't get a patent.
Understood.
Yeah.
Understood.
So in terms of the next step, after you have an idea, whether your idea or your invention is potentially patentable, you really need to get an intellectual property expert to start working with you. So in Trinidad, we have a range of options. So you have your typical law firm that you can go to. So off the top of my head, JD Salier is probably one of the leading intellectual property law firms. They have a specialty unit that covers IP, and they have a drafter in-house. You also have intellectual property consultancies, and we could talk about that at the back end of the conversation today, where there are intellectual property experts available. You can also seek some advice from the intellectual property office.
Okay, wow, that's a lot.
Yes.
That's excellent. So as an entrepreneur, we're starting out, we understand, okay, we need to do the research. And that goes without saying. So we need to get on Google, we need to do the research to find out, okay, where do we sit in terms of patterns? Where can we get the information for intellectual property? If we need a consultant, who can we bring in? And as you recommended, JDCLA is a good place to start.
Yeah.
But if it is, I am concerned about, I have my patent, but I'm now concerned about IP infringement
Yes.
or theft.
Yes.
What sort of parameters can I put in place to really safeguard my
Yeah. So the first one I want to tackle is the idea of theft and intellectual property, because theft under law requires that there is a taking of the item and that person, when you take it from them, can't use it. So that's a sort of a misnomer for IP, because there's no theft in IP because it's an intangible.
Okay.
So even though you take it, I can still use it. So legally, theft doesn't apply. So it's typically intellectual property infringement. And that's a great question, because the reality is that if you have invented something, you have it patented, the minute it's patented and it's registered, that information is disclosed to the public. So anybody can technically go and do the same patent search now, find your patent and recreate it. So this is where intellectual property enforcement mechanisms come into play. So what I want to say is, I also want to dispel another myth that we don't have intellectual property laws that are strong in Trinidad or the Caribbean. Actually, Trinidad and Tobago is one of the countries with one of the most robust intellectual property frameworks in the entire Western Hemisphere, potentially even in the world. We are signatory to most of the modern international treaties, so our protection is up there. So in terms of what you can do at a business level is really know what your intellectual property is. So you need to do an audit, figure out, or not just the patent, but what else do you have under your house?
Okay.
And then the next step is do license deals. So any deal that anytime you're sharing that pattern, anytime you're giving somebody permission to use it, have a contract. So it's really about contracting. That's the best way to manage your intellectual property. Ensure you have written contracts that are very clear about what the terms and conditions for the use of that patent include. And then if it's the case that somebody is infringing your patent or your other pieces of IP, you need to then have a mechanism to follow up. And that's really where you're going to have to rely on the law and potentially end up in court. But the challenge is, court is expensive.
Yes.
It's time consuming. It's frustrating. The average case is going to take you, minimum 2 years before you get a first hearing. In Trinidad and Tobago, there's only been 2 patent cases. And in those cases, the discussion wasn't about the patent. So we have a culture of being non-litigious. So I think that needs to change. Businesses need to know what they have and what they protect. The same way that somebody will ensure that they remove a squatter from their land, or that they will litigate to get control of their piece of land. It's the same for intellectual property. It's property at the end of the day.
So I just want to put it a little bit in layman's terms, because I want to make sure that our viewing audience understands.
Sure.
So for example, let's look at technology.
Yeah.
If I am a programmer in technology and I have created a code for whatever the particular application is, but that is like a subset of a bigger program. And I'm now saying to myself, okay, I am going to give Justin this portion of my code so that he can build on it. Are you saying to me that that portion needs to be licensed to the individual, because that's now my intellectual property?
Yeah.
So I'm licensing it to them so then they can now build on it.
Yes.
And that is the same concept if, and I think one of our audience members asks about wireframing. So in the same context, it's the same thing with wireframing or any kind of prototype. That portion of it you must license before you distribute.
Yeah. So I think from a very simple perspective, that is the advice overall.
Okay.
But I want to sort of knuckle that down a little bit. So in terms of the code, in the US, that might qualify for patent protection. However, in most of the Commonwealth world, it's going to come under copyright. So when you have source code, object code, any sort of computer code, it's going to come under copyright as a literary work. But you're absolutely right that the first step is license it, or if you want to just sell it outright, assign it to the other entity, and you have a deal in place about how that is going to be used and its incorporation and subsequent usage and all of these kinds of things in your license or your contract. In terms of the wireframing, that's a slightly different approach, because it depends on, is it a wireframe that is going to be patented, or is it something that the patenting process has already begun? Because again, novelty is key. And in order to maintain the novelty, you cannot disclose that invention. You have to keep it secret until the patent is filed or the patent is already received. There is a grace period if things like leaks and situations like that
I was
happen.
going to ask that. If it is there's somebody inside that is literally built,
Yeah.
they've taken your idea and you're
Yeah.
now neck and neck, how is that treated?
Yeah, so patents is a first to file system, but there is a grace period for things like leaks or breach of confidential information and things like that. So really and truly, if you don't have a patent or your patent is not in process as yet, meaning the disclosure has not taken place legally, you want to keep your idea secret. So the best way to do that, non-disclosure agreement. Anytime you're sharing it, you're discussing it, you're mentioning it, you're trying to reference it before you start that conversation, non-disclosure agreement. So have them sign it.
But just, I mean, NDAs are lovely on paper,
Sure, of course.
but they're just paper because,
Yes.
and you said it, we're not a litigious society.
Mhm.
So you do an NDA.
And somebody takes that throws it in the bin, right? And then they
Yes.
share your idea. At least that way you have the leg to stand up on, where if you have to file a patent, you can say, well, look, I actually invented this. It was secret up until this point. I disclosed it in this way. We had an NDA, so this is confidential information. At least the IPO or the courts, if it gets to that point, will say, well, okay, this was secret. This was confidential. The novelty was not destroyed.
Okay.
Because the opposite situation, if you don't have the NDA, it leaks or it's shared or you give it to somebody, then it's considered disclosed and then it's no longer novel. And
Okay.
therefore it's no longer patentable. So at least you have that safeguard. Even if you don't have to use it or you don't want to use it, you have the safeguard.
So let me ask you another question. There's infringement.
Yes.
You're in court. What happens at this point? Is it that there is, whether it's code, wireframing, whatever it may be, is it that everything goes on pause, so nothing can be used until it's settled in court?
So it depends. If the one party requires an injunction, then yeah, everything is going to be frozen. That's not to say that the layperson in the street is going to respect that necessarily, but legally, you can ask for an injunction and everything is paused.
Okay.
But again, it's going to depend on what rights you have, because it might be the case that you don't have a patent yet, and it's just a disclosure, and therefore it's a breach of contract being discussed rather than a breach of intellectual property or infringement of intellectual property. So again, this is why knowing what intellectual property covers, knowing the different stages and the processes involved, and understanding the scope of your rights is so critical. If you don't have that, then it's kind of like you don't know what your business is about.
And that's why it's important to get an expert involved, because
Exactly.
the depth of knowledge that is required, while you may have an overview,
Yeah.
that depth of knowledge, you really need to bring on an expert that will say,
Absolutely.
it's
Absolutely.
this, it's that, etc., etc.
Yes, definitely.
Understood. Understood. Let's jump back into some of the questions. Those are my questions, guys. I was stealing some time. So I want to find out, Justin, with the rapid growth of digital business,
Yeah.
how should entrepreneurs approach protecting the IP in online markets and across borders, especially with AI playing such a critical role these days?
Yes.
How are we dealing with that?
Yeah. So the first thing is, again, know which intellectual property right is in play. Is it a copyright? Is it a trademark? Is it a patent? Is it something else? So in terms of copyright works online, I think the starting point to say is that copyright subsists. So the minute that you've created that copyright work, as long as it's your own intellectual creation, you already have copyright. You don't have to do anything else. You don't need to register. The only country that requires legally registration is the US, and that's for procedural reasons to be able to litigate. So there's no requirement to actually register your copyright. That differs from trademarks and patents, where you have to register the right in order to get protection. So understanding which rights you have in play first, I think that's a starting point. In terms of copyright works, the best you can really do, especially in the age of AI, is one, know where you're putting your work, right? Make sure your name is on it. Make sure your contact information is on it. You can use technological protection measures, so DRM access and other, digital locks.
Yeah.
Yeah.
Yes.
You can do that. So if you're sharing your information with, third parties, maybe lock and key,
Okay.
right? Passwords, simple things like that. Because once it gets out there into the internet, it's kind of the wild, wild west. There's no
Agreed.
option for you to pull it back. Yes, you could litigate and stop somebody from using it. But let's say, your paper goes online, you have a project file or something, and it goes online and somebody in Turkey is using it. Are you going to go to Turkey and sue them?
Exactly.
No. So that's one of the drawbacks of intellectual property in that way. And it really is a lot of times a big right holder game. So this is why you see the music studios, you see the movie studios being the ones that are being litigious, because their products, they invested millions of dollars in it. But of course, we have entities here that are investing millions of dollars in their IP. So it doesn't stop you from don't not share, but just be mindful of how and when you share and who you share with.
Yes.
Right? So put your, basic lock and key in place. You're not going to leave your house open with a door with no lock and
Yeah.
or latch. Right? It's same principle applying here. In terms of trademarks and patents, we'll talk about patents after. Trademarks, get your trademark in your home country. And then every target market that you're focusing on, get a trademark, get the same trademark or similar trademark registered there.
Okay.
Right? And in Trinidad and Tobago, we have the option of the Madrid Protocol, which allows us to, once you have the mark in your territory, your home country, you can file one additional piece of paperwork and through the Madrid Protocol, gain access to over 120 other territories for your trademark.
Oh, wow, that's
You do have to pay the fees in each country and meet the requirements in each country, but it's one piece of paperwork. And this system is handled by Ep1, facilitated through the intellectual property offices. So it's a really efficient way. It is expensive overall.
That's what I was going to ask. Is the
Right.
pricing prohibitive?
So you have to pay the fees in each country, and on average, it's a little bit more expensive to use the system because they add like an admin fee on top of it. And then there's a standard fee. I think it's about 500 and some, like 550 or 600 Swiss francs
Okay.
to access that system. But if you're going to be filing in 10, 15, 20, 25 countries, the time you save is going to be cost effective. Also avoiding the requirement of having, let's say, attorneys or trademark agents in every country that you're going to file. You can do it from your home country. So it's a really efficient process. In terms of patents, you do have the Patent Corporation Treaty, which allows a similar sort of setup, but patents take long to file.
An average, tell me how
So
long?
for patents, you're looking at from the date of filing, it could be 2 years, it could be 3 years,
Oh, wow.
right? And you only get 20 years protection overall.
And then you do it all over again and takes another 2 years? Or is it that it's once you're in the system,
When you're in the
it goes a
system,
lot faster?
Well, for 20, no, so it doesn't matter. Every invention, because of how detailed the search has to be,
Yes.
because of that novelty requirement, you're looking at 2 to 3 years, and you have 20 years protection. And then when 20 years is over, it's public domain. Anybody can use it.
So you got to move very quickly.
Yeah.
To guard your back.
So this is why pharmaceutical companies in particular are so heavy-handed with the enforcement of their patents. Because after, let's think about it in that way, you get 3 years to get it patented, and then you have to do clinical trials and all of these things. It could be 5, 6, 7 years down the line before your drug goes on sale.
Yes.
Yeah.
That is, wow.
Yeah, and that's also when the trademark becomes important, because when the patent expires, and this applies to all industries, if the patent expires, you're going to rely on the brand.
Correct.
So you can get a generic, but people know the brand and people like the brand because they quality control and other measures, and this is why maintaining your brand is so important. So that's where the trademarks come in. So I know this is a lot.
Yeah, it's a lot, and I'm thinking it's not something that a company independently can do on their. It's something that you either outsource to an IP, consultancy, or you bring in somebody. But it's to sit and try and do this on your own is really going to be difficult because it's quite a lot to digest.
Yes.
Yeah.
Yeah.
So you're busy, Justin. Very busy, to say the least. I have another question. What are the first steps an entrepreneur can take right now, today, to begin to protect their IP?
Okay, so again, I'm an educator in the first place. So my first answer is always educate yourself about what intellectual property rights are, so that then you can at least do the basic IP audit and figure out what you have. When you know it's a copyright, a trademark, a patent, only then you can move forward. So my first suggestion is usually secure your brand in the first place, because that's the thing that's most forward facing to the customer or the consumer.
Agreed.
So you need to mark your presence in the business world, and the best way to do that is get a trademark, right?
Okay.
So start with that. What's your brand? No matter how good the product you have is, or no matter how magical it is at fixing problems, if it isn't visible as a brand, if people can't interact with it, they're not going to buy it, right? So like I said, you could have the magic pill, but your branding sucks, nobody's going to see it. Nobody's going to buy it. So start with your brand. That's the easiest one. That's low level. It's something that everybody can work on. So get a logo, get a brand name. Start thinking about, is someone else already using that? So do your searches yourself. Again, there are databases online. Search, do reverse Google image search to see if your logo is already out there. I'll give you a horror story, clients. So I'll give, I love to give the horror stories. Because that's the most effective way to convey this information. I had a client came to us for a trademark, and we ran the search, the trademark search came back that the entire logo was copied. So that person had to go back and rebrand, and they already had packaging, they already had branding, they already had website, IG, everything. So market rebrand. So get rid of the packaging, have to do everything. That's the kind of cost that you could be running into if you don't understand how intellectual property works in your business.
I'm going to take a little sidestep, Justin,
Sure.
because you're talking about that. I know when you're registering, let's say, for example, your company name.
Yes.
If my company name is too close to your company
Yes.
name, then I can't use it. Does it work for logos as well? If your logo and my logo looks a little too similar,
Yeah.
same thing?
So it's two elements at play there. So let's start with the first bit. So the company is registry.
Okay.
They are not meant to allow anything on your register that is going to be too similar, or confusingly similar. The Trademark Act and the company's the Business Names Act are meant to interact. They don't in Trinidad.
Okay.
So it's meant to, but it doesn't happen. So somebody can get a registered business name, and then the trademark shouldn't really be granted if a registered business name is already in that exact same sort of looking thing. But I think the differentiation that we've drawn in Trinidad, unlike let's say in Barbados, where you have to, in order to get a trademark, you also must have the registered name lining up.
Yes.
So we don't have that correlation happening in Trinidad. So in Trinidad, what happens is, and I'll give you the example of McDonald's. If anyone's been to McDonald's recently, when you look at the bill, it says the registered company is like El Octador Limited or something like Golden Arches Limited, right?
Okay.
But McDonald's is a trademark.
Mhm.
So your business name and your trademark don't need to line up. Your trademark is the forward-facing entity to the consumer. Your business name is your legal trading name.
Gotcha.
So yeah, you can line them up. Don't have to. But don't think that because you've registered a company name that grants you any protection on the trademarks. And that's one of the most common misconceptions that we've seen in Trinidad recently. A lot of people come to us and ask us, well, I already have a business registration. Why should I get a trademark? Well, business registration and business names don't grant you any rights. There's no protection. There's no infringing on a business name. All it means is that somebody can't come and register the same name or confusingly similar name.
Gotcha.
But that doesn't give you any positive rights to stop anybody from trading under that name.
Okay.
So it's about enforcement as well. That's where trademarks come into play, giving you those rights to control the use of that trademark. So I know that's a long-winded way of answering the first part of the question. So yeah, difference between business name and trademark. Definitely get your trademark sorted out after you get a business name registered.
Another thing, you mentioned getting an IP audit.
Yes.
Explain to me exactly what is the requirements for getting it, because I know when you're doing a financial audit, an IT audit, it's a ton of work.
Yes.
It's expensive.
It is.
There's a lot of resources internally that are needed to contribute to that audit.
Yeah.
What are the requirements for an IP audit? What's the average cost? If you can give us that, give us a little bit more insight. So somebody having to do that as one of the key steps, what are they going to be looking forward to?
Right. So it is really going to depend on the size of the enterprise.
Okay.
So if you're looking at let's say a micro enterprise, you're looking at something probably like ballpark figure like $5,000, because we're going to have to sit with the people who are in the business and determine what you have.
Mhm.
Right. So people don't necessarily always assess what their business uses. So it's not just what you have, but also what you're using. So we're in Magnolia Cafe right now. I'm hearing music playing in the background. That's part of the IP audit. Do you have a cut license to play that music?
Mhm.
Right? And people say, oh, not just playing the radio. No, any music being played in public,
Yes.
you need a cut license.
Every carnival we deal with that, don't we?
Exactly. And it's like, rinse and repeat every year, same story, right? So that's part of the IP audit. Just knowing that you're using somebody else's intellectual property. That's part of the audit.
Okay.
Do you have permission to use that? What risk are you exposing yourself to? Because then it's also a matter of risk exposure. Some things we'll be like, oh, okay, well, we'll flag the risk, but maybe this is low risk, so we don't need to be overly concerned about it right now. You're probably not going to get sued for this. But then there may be other things you're doing. Your logo looks like somebody else's logo down the street. They could come and sue you.
Gotcha.
Right. So we're going to be looking at your branding. We're going to be looking at your products. We're going to be looking at your packaging. We're going to be looking at what you're using in your premises. We're going to be looking at your measures with your employees. Are they creating intellectual property rights? Because a big problem that happens is you've hired persons. People are creating things within their job description and outside the job description. So it becomes a matter of employment law as well.
Yeah.
Do you own what your employees are creating? So again, depending on also now with outsourcing of employment, you might have persons based outside, and the laws in that contract mightn't be specified. So they might be based on the law that they're the place on there.
But if I'm understanding you correctly, ideally in the employee contract, it should stipulate whatever you're creating is basically
The companies
owned
are
by- right.
ideally,
Got you.
unless your agreement with your employees is keep what you've created.
Oh, okay.
So that's an option as
Okay,
well. Contract
okay.
can dictate. But
Because I
yeah.
know a lot of companies, if you're creating, that means you're putting it on their server. You're putting it on their tangible, whether it's a server, their desktop, laptop,
Yes,
etc. So that way,
exactly.
when you leave their material with them.
Yes.
And ideally, that's the best
Yeah.
way to go about safeguarding the information.
Yeah, you want, as a company, you're paying these people to do these things. You should want to own it again, otherwise you're leaking resources,
Yeah.
right? What about also situations where people are creating things using the materials, not necessarily in the job description, but using the company laptop, using the company software?
Yes.
You know, you want to cover all of those ends as well. So it's also about data. You're collecting data. What are you doing with that data? How you store it? So yeah, data is not necessarily going to be intellectual property specific, but the way in which you collect and house that data might be IP relevant. So copyright databases, for example, the information itself is not, the data itself is not copyrightable, but the database in which you've constructed to hold that data and maybe process it into information becomes copyrightable.
Okay.
So understanding that also comes. So when we're looking at IP, it's not just hardcore IP. We're looking at other areas of law as well: employment, data privacy,
It's quite expansive.
competition law, etc., etc.
Okay.
Yes, it's a lot in place. That's what the audit entails.
And how often do you need to do an IP audit?
Again, it's going to be dependent on the enterprise. If you're let's say early to now starting out,
Let's say small to medium size
Right.
enterprises. Let's look at that size.
sure. I'd probably suggest once every 5 years.
Okay. Okay.
Because as
Okay.
time goes, you've come up with new products, new processes,
Understood.
that sort of thing.
But if it's a enterprise business, the time frame is shorter
Yeah,
because the cycle time of creating things.
exactly.
is longer.
Especially if you're creating new products that replace the old products, or you're turning over stuff quickly, or you're diverging into new areas at a rapid rate. Yeah.
Yes.
Then it comes every 2 years kind of thing. Yeah.
Okay. And how long roughly does it take small to medium sized business enterprise? How long would an IP audit take?
If we do it intensive, I think within 2 weeks it can be done.
And that's with them providing you with all
All
the
the
resources
information
you
that you
need,
need.
information,
Yeah.
etc.
Yeah. And a lot of the time it's really just talking to the people who are involved and the decision makers.
So it's almost like an interview
Yes.
of sorts,
Yeah.
yes?
Yes. Yeah.
And that's for small to medium. But if you're dealing with enterprise, how long would that time
If
be?
you're looking at large enterprises, it could be 3 months.
Wow.
Because you have to go through every department, and then you have to make sure all the departments know what each other department is doing, and where that information is coming from, and how it's housed, and who's using it. Is it internal? Is it external? So you have a lot more going on in that context.
That is
Yeah.
really, really good information, Justin. So, Justin, we're about to wrap up. So, I would like you to really share with us a good takeaway that our scale-up team, our business owners, our entrepreneurs who are into their business 5, 10, 15 years or more into their business,
Yeah.
a takeaway that they can have that they can carry right now with them pertaining to IP. What would that be?
Yeah. So again, that's educate yourself. All right. So let me give you some resources to educate yourself. The World Intellectual Property Organization, just type in on Google WIPO, WIPO. They have lots of resources. If you're looking for something more local, my own consultancy, Clover Consultancy, Clover, with kind of minimalizing branding now. We have a website, so we have information. We have some blog posts covering the latest news on IP locally, regionally. Also some explanations as to the different types of rights and how they work in Trinidad. So you can check us out for that, or just do a general Google search about copyright, trademarks, patents, whichever area that you're interested in. Be careful though. A lot of misinformation out there, so don't take it for granted that Google has it right, or whoever's posting things. A lot of information is posted in the context of the US, which has zero relevance to us.
So double check.
So if it's US based, it's probably not useful. I'll give you an example. Works for hire. We've seen that in contracts many times. There's no works for hire doctrine in Trinidad and Tobago.
Gotcha.
So anytime I see that in a contract, I know the person doesn't know what they're talking about. The other thing that you can do is immediately protect your brand as of yesterday. If you don't have a trademark on your brand, you're opening yourself up to be free-ridden on. So somebody's going to ride on your coattails and take advantage of all the investment that you've made in your brand. So secure your trademark list. It's the easiest thing to do. If you haven't done an IP audit, do an IP audit. If you want to do it yourself, you need to educate yourself about the various rights, but then at least know what you're using in your business, and if you own it, and if you don't use it, and then figure out the risk from that.
Associated with it.
Exactly.
Gotcha.
So I know it can be expensive, it could be time consuming, but if anyone wants to do it themselves, educate yourself about the rights, do an internal IP audit. I think that's the immediate starting points, that if you do that, you're already in a better place.
Oh, thank you so much, Justin. This is excellent, excellent information, guys. This is where you are going to get all the key bits of information to scaling up your business. This podcast is on intellectual property, and we have lots more coming later on in the year. So stay tuned, stay informed, scaling up your business.